we would accept the CI if some aspects of it are taken out. Ladies and gentlemen of the media, nothing in this CI is worth accepting for purposes of enactment. And the reason is very simple. There is an existing law that comprises CI 91, which was enacted in 2016, and then CI 126, which was enacted in 2019. The Parliament of Ghana passed both for purposes of voter registration, and both laws are in existence. Now, if you want to change the existing law, you need to show that that law is not working, that there are deficiencies with the law that need to be remedied. As we speak now, the Electoral Commission has not said anything convincing about the deficiencies of the existing law. So let me give you one example. And yesterday we made this point abundantly clear on the floor of Parliament. Ladies and gentlemen of the media, you can read for yourselves. Please go and take CI 91 and look at Regulation 9, okay, on continuous registration. Regulation 9 provides the basis for the conduct of registration of voters on a continual basis, and that includes limited registration. If you look at the proposed CI, the substantive content of the CI in Regulation 9 is the same as the old CI. Meanwhile, the Electoral Commission wants us to believe that the reason why she is bringing the new law is so that they can seamlessly conduct continuous registration. So that is a palpable lie. There is no basis whatsoever for what she's doing, because if you are reenacting the provision in the same fashion, it means that you can use the same provision in order to do what you are proposing to do. So there's no basis for it. And the minority leader has made very clear the reasons why saying that the Ghana card is going to be the sole proof of identity for voter registration purposes is inimical to the conduct of registration, especially in rural areas. I remember distinctly when we were conducting the voter ID card litigation before the Supreme Court. I gave one example. In Daboya Mankarago, okay, there is a village that is 85 kilometers to the district center. So if you require that this person, any person of 18 years and above, who has not got a voter ID card, should travel 85 kilometers to the district center in order to be able to, register to vote. Okay, do you expect ordinary Ghanaians with limited resources to be able to afford, transportation and the cost of travel 85 kilometers to the district center in order to be able to vote? So we made the point clear that this was going to lead to voter suppression. It is going to lead to a situation where people will just give up their right to vote under Article 42 of the Constitution. So take democracy to the doorsteps of the people by making the polling stations the centers of registration. That is what has been the practice since 1992, and that is what has served us well as a country. There is no reason why we should change. So in sum, your question as to whether or not there is anything that should be taken out of the new CI so that we can accept it for enactment will be answered by saying that maintain the existing law, because the existing law is working and it is working very well. If Jean Mensa were a minister bringing a bill to Parliament, she would have had to bring a memorandum that will spell out the mischief that the bill is seeking to cure. For us as a minority, she has not been able to do that convincingly, and we will not accept the new CI, period.